Good morning, everybody. My name is John Kloppenstein. I'm a private lawyer here in the state of California, and I have been practicing for the past 20 years, mostly criminal law. And today we're going to be talking about fraud. And I read the materials, you have to understand that fraud comes up in a lot of different ways in a law exam or in law school. It comes up as an intentional tort, and it comes up as a crime, and it can come up in this particular scenario, which is a case that came to me recently where a woman went over and borrowed money from an 85, 90-year-old woman, went to the bank. The woman gave the money to this younger woman, and she used it to pay her mortgage, and they charged her with elder abuse, financial elder abuse, because of the fact that the younger woman had no intent to pay back the older woman money, and so it can raise its head in a lot of different ways, and so you need to be aware that that fraud is a very, very broad area, and it covers a lot of the commercial areas, and so to get into it here, I see that there is the Fraud Act of 2006, which apparently, according to the material, simplified the fraud, and it broke it down into false representations, failure to disclose information, and abuse of position. And now, if you go to 12.3.1, and that is fraud by representation, and they get into the actus reus and the mens reus. And basically, the point that they're trying to make here is that a silence is not a representation. Now, I disagree with that in a way, because of the fact that in particular relationships, and we'll get into it later, we have fiduciary relationships where if in a fiduciary, attorney-client, trustee, trustor, beneficiaries, these kinds of relationships, silence would definitely become a representation under the definition in your book. And it says that a representation is dishonestly makes a false representation, intends by making the representation to make a gain for himself or another, and to cause loss to another or to expose another to risk of loss. A representation is false if it's untrue or misleading. And then they get into some of these things regarding turning back the odometer. Turning back the odometer and being silent about it. They're saying that is not a representation of this, and that may be true, and it may cover a very, very small area of people, but generally speaking, if a car dealership is turning back the odometer and not telling people about it, here in California we have what we call the Carfax, which is a history of the car, which is by law has to go along with the sale of the car to prevent these kinds of fraudulent representations that are made. So it goes on and on and on regarding your actus reus, and they have a lot of examples, which I really don't want to get into here. Anyway, the most important thing is that it's a representation, and it can be a representation, and it can be an implied representation. It could be anything which basically is misleading. So anything that is considered to be misleading in any way, which is going to benefit the individual who is making that representation, that is going to be considered a false representation and is going to be the actus reus regarding this particular, which is making a representation. So, moving on, we move on to the mens rea, and getting into the mens rea, which is failing to disclose information, and that is, again, you make a representation that the car has so many miles on the car, and when you turn back the odometer and it doesn't, then basically that is the mens rea and the actus rea, and that is the completion of the crime. So failing to disclose information is generally is going to be your main mens rea, and that's in the Fraud Act, and that's in 2.3.2. Moving along, obtaining services dishonestly, and this is where you have your apparently under this act, this would be going into a movie theater and not paying. This would be going in and getting a haircut and not paying. These are the kinds of things that they're making reference here, and which is covered by this Fraud Act of 2006. And so the elements there is a person is guilty if he obtains services for himself or another by a dishonest act and in breach of subsection 2. Now, I don't like that term breach. Breach implies there's a contract. It implies a civil, that this is civil as opposed to criminal. You know, generally in California, you wouldn't have that kind of language at all in the statute. The statute would be a misrepresentation that's made for the gain of another. A lot of times it's you know, and you can be, again, it can raise its head by forging checks, stealing checks. I represented a group of people who were taking information out of post office mailboxes, and then making credit cards, checks through the computer. They had the ability to make these things, and then they were writing checks on people's names who they were stealing information from the post office mailboxes. And of course, the federal government got involved, the state government got involved, and it was a big deal, and it involved a lot of people. And that is your general, you know, kinds of fraud. Identity fraud has become a very, very big area of the law, where people take your identity off the internet. You give them your credit card information, and they then are able to take that information and then use it and steal it, and then purchase items off the internet and other things, and even, you know, create credit cards and things. And this is your general kinds of fraud. You know, this area of going in and getting a, you know, haircut and running out, or going into a restaurant and trying to run out. I mean, these are really, really pretty minor kinds of frauds. It's called defrauding the innkeeper, going in and purchasing a meal with no intent of paying. You know, this is something that, again, here in California is a misdemeanor. You see it, but it's not prosecuted that often. I think in the last 10 years, I've maybe seen one or two of these cases that I've handled, and so not to I guess diminish or to minimize the this obtaining services dishonestly. It's something that apparently is in your materials and you need to know, but I think in the real world, this is something you don't really see, such as entering a cinema without paying, having a haircut without paying, ordering a meal in a restaurant knowing no one needs to pay. I mean, these things do happen, but it again is minimal, and I guess it's something that you should look for on a bar exam or a law exam. But in the real world, it's minimal. And then they talk about making off without payment, and then they go into theft. So this becomes, in a way, a confusing area, because not only do you have fraud, but then you're adding theft into this, and so when you're talking about fraud, you have to understand that fraud covers a lot of areas. It covers theft, it covers forgery, it covers stealing, and it covers, which I think is the most important element, or the most important is the fiduciary, meaning that there's a relationship between a patient and a doctor, and you see this on a bar exam a lot, where a woman goes in, a guy represents himself to be a gynecologist, he has her take her clothes off, he ends up having sex with her, and of course it's without, it's supposed to be consensual because of the doctor or a relationship, but that's fraud. That is clearly fraud, and that is clearly, not only is that a battery, but that is a crime. It's rape. So not only do you have a civil remedy in the terms of battery, but you have a situation where you have a crime which is going to be rape, because of the fact that there isn't any relationship between the doctor. The guy's not a doctor, and so the woman is giving consent, and it's consent that is vitiated through the fraud. And so as a result of all that, that's where you get these crimes, and that's in the area where you really see on a bar exam or on a these kinds of exams, you're going to see this kind of fact pattern, because they're going to want you to know that there is this fiduciary relationship, and then of course the fiduciary relationships, the doctor, the attorney, client, where there's an embezzlement of trust funds. And again, you may see this on ethics too, where you have a situation where an attorney enters into some sort of agreement with the client to do some business together. The attorney then prepares contracts and, as the attorney, but he's a partner, and then what happens is, of course, the business goes bad, and the client is going to claim that the attorney, through his poor efforts, was involved in the reason that the business went bad, and so there's an ethical violation, because here in California, through the professional responsibility rules, an attorney cannot go into business with a client. There has to be a clear relationship, meaning there needs to be an attorney-client relationship. You can't merge that in any sort of way. And so there's another area where maybe fraud comes up in terms of ethics, professional responsibility. So when you see these kinds of things, you see misrepresentation. And this, again, can be in the contract area, too. You can, when you use breach in the civil area, that can be a misrepresentation that's induces somebody into a contract. A contract. What happened? Did I go offline? I'm not sure. The computer went blank. Maybe it's. Okay.
Yeah, you're online.
Oh, okay. Sorry about that. I thought we had. Oh no. Okay. Oh, okay.
It doesn't log off.
Okay. So, you know, these are the areas that I think we need to be looking at. And so, what's this from Road?
That's fine.
Oh,
yeah.
Everything's fine?
Mm-hmm.
Oh, okay. Great. So, these are the areas that you need to be, you know, looking at. And so, you know, to take a fact pattern, you may have a situation where an attorney, you know, a contractor goes to an attorney, and the attorney is to drop the contract. The attorney sees an opportunity and gets involved in some way, or some misrepresentations that are made, which could result ultimately in maybe this being a breach of contract, an ethics, a intentional tort, and it could result in being a crime. So this fraud area, again, covers a very, very large area of the law, even though we have this Fraud Act 2006 that covers some specific kinds of conducts. I think you need to be on the alert for a lot of various areas, and you know, in California on the bar exam, there's a lot of crossover type questions that cross over from criminal law to intentional torts to contracts and into remedies of those various areas. And so, you know, you need to look. And I would look at what the examiner is asking you. If they're saying what sort of crimes, then I think you're aware and you're in the area of criminal law. If they're just talking about, you know, what kinds of things are going on, sort of a real general, then you're going to need to cover a lot of different areas. So that is really pretty much fraud. You can read and you can get you know, the elements of the various three areas that they make reference to. You can see where the actus rea and the actus reus and the mens reus. But generally speaking, we're talking about someone making a representation that is false or misleading, and they know that it's false or misleading, and then they are able to make some gain as a result of that. And that really are the three elements that you're going to need to know in the fraud area. So I believe that really covers fraud, and I'd like to go into the next area, which they call, which is Chapter 13, criminal damage. Now, criminal damage, I've never really heard of. It may be something that's specific to England, Canada, to English type law, though they do talk about arson, and they bring up arson, and, you know, and they talk about simple criminal damage as opposed to some severe criminal damage. And I had an arson case, and you have to understand that two elements of arson. One is that just mere charring of the property is enough for arson. However, it needs to put somebody in danger of either serious bodily injury or death, so that if there isn't anybody in the in the house or in the apartment, then arson really doesn't apply because there isn't anybody that's going to be seriously injured or is going to die as a result of this. So it's a really kind of a trick question when it comes to arson, in that what they'll do is somebody will try to burn down a building or something which is empty, and that is not arson, but that would be, a crime of seriously causing damage to a property, would be a property crime, and would result in certainly a conviction, but it wouldn't result in conviction of arson. So be careful in that area. So when they talk about simple criminal damages, I guess that would be trampling on some of their property, and causing some sort of damage to minor damage to a fence, to a yard, something like that. Now, they do have, they bring in the defense of impossibility, or not impossibility, but of, excuse me, the defense of coming to the rescue of another, this kind of thing, meaning that they may have to break down a fence to save others. They may have to, and so that is a defense to this area of the law, and it's not impossibility, but it's a lawful. They call it a lawful excuse. So basically, what this says is that somebody general defense, and this is 13.1.6, where apart from the general defenses, there's belief, owner's consent, and belief that it's a necessity. That's what I'm thinking. Necessity to protect one's own property. So the defense of necessity will alleviate any criminal charges regarding, destruction of property. So I think that covers that area. Of course, they get into the aggravated criminal damages, which is basically what we're talking about arson here, and they get into the elements of arson. And one of the things that, again, that's very important is that in California, it's mere charring, and it is the fact that someone has to be either inside the property, or it has to be put the fire in such a way where maybe other buildings would be subject to, people living in those buildings would be subject to burning down to death or being seriously injured. If you don't have that situation, then then there isn't an arson. Now, moving on to Chapter 14, criminal attempts. This is an area that's very important. It's attempted, and pretty much every crime has an attempt. And we have attempted murder, we have attempted battery, we have attempted arson even. And what these are preparation type crimes, meaning that they don't get to completion, meaning that the actus rea and the mens rea are not complete and there isn't a crime. And what this is that this has to do with an overt act. It means that there is something, a person goes and he's going to burn down a house, and he is got gasoline and he's putting it on the wood, and he's just about to light the fire when the police come and they interrupt him, and so that's an attempted arson. Somebody is going to commit a homicide, They go and they're going to buy a gun, they're going to get the ammunition, they're going to, this kind of thing. And so this is a preparatory, and there needs to be some sort of overt act, some sort of act that is done in the preparatory stage that is going to show the intent to commit the completed crime. And this is a specific intent crime, meaning that there is a very high mens rea that needs to be shown, and so yeah, okay. And so what you need to know about these attempts is that they're not completed crimes. So that if you're looking through and you're reading through a law exam, bar exam type situation, and you don't see a completed crime, and you know it's an attempt, then you need to get into the really issue. The issue is whether or not there's been an overt act, meaning that there's been something that's been done that is going to go towards the furtherance of the crime. Furtherance of the crime could mean purchasing gasoline on arson, could be purchasing guns in a murder, could be bank robber would be buying masks and gloves and things to cover the face and arms so that the cameras can't see the bank robber. These are areas where you're going to see that there is the overt act that is leading towards the crime, but it's not complete. Somehow or another, it gets interrupted. The teller, hits the alarm, and they come in to get away with the money, so they haven't completed the bank robbery. These are, the police get a tip, and they come in and they steal all the guns and this kind of thing. So this is the area of attempts, and they talk about on 14.2.1, when is an act more than merely preparatory? And that is another way of saying an overt act, which is the element here in California, the key element. And so a little tip on how to write an exam, a bar exam. I've been working with an individual that's going to be taking the bar exam here in California. And what the key thing is to take the rule and break the elements of the rule up into individual categories, and then apply the facts as indicated in the exam to the rule. So generally speaking, you would frame an issue, you would recite the rule, and the rule usually has a number of elements in it. In crimes, criminal law is an element type course, as opposed to the same as torts and some of these others. You put the rule, you then break the rule down into individual categories, and you then would recite the facts to the rule, and then sometimes a particular element of the rule is the key. So, like for example, in attempts, the usual key element is going to be an overt act, and it's going to be factual whether or not the particular factual pattern in the exam is going to show whether or not a person did an overt act or not. It's going to be close. It doesn't matter how you conclude because the examiner doesn't care. It's a matter of just being able to see the issue and to raise it and to discuss it intelligently. And so with that, I know it's a little bit less than an hour. I've been very quick, and so I'll take questions now. Any questions? Turn on your mic if you have a question.
I have a question.
You have a question? Who's this?
Yeah, I do. It's Rose.
Rose,
it's Rosemary.
Okay.
That's right.
Go ahead, Rose. Shoot.
When you're in a courtroom, are you following the same model of defining the crime and breaking down the elements and then applying the fact pattern? So the way we're answering these exam questions, is that the way you would be doing it in a courtroom?
No, the answer is no, because of the fact that it's done through evidence. It's done through people going up to the stand and testifying. There's a jury instruction that says that anything a lawyer says is not evidence, and to discount anything that a lawyer says as evidence. It's not some. I mean, obviously they can consider closing and opening because you know, these are just sort of directional and they're arguments that are made. But a lawyer is going to take the testimony of individuals and is going to say, you know, John said this, Joe said that, Susie said this, and whatever, and then conclude basically based on the evidence doesn't show beyond a reasonable doubt that this particular person committed the crime. So no, the answer is, but you know, when you're writing briefs and you're writing, you know, trial briefs or things like that, it is done in kind of an issue rule analysis format. So anytime you're writing things, it's done in that way. But generally in the courtroom, the answer is no. Anything else, Rose? Hello?
No, I'm good, thanks. Thanks for the information.
Yeah. Okay. You have any questions about the subject of fraud? Okay. Well, I guess if there isn't any further questions, I'm done. Come out. Thanks.